his wore a nice suit today, so we want to be able to see him.
Well, he always wears a nice suit.
Thank you, gentlemen. Mr. Chair and Commissioners, the hour is late. I'll be succinct. I'm going to hand a copy of these for each of you. It is not very often that we encounter an error in the City of Miami's zoning atlas, much less one that is 44 years old, but that is the case here. And when that happens, when a graphical error is made in the City of Miami zoning atlas, we administratively correct it. In this particular case, I wanted to bring it to your attention because of how unusual it is and because I certainly wanted to make this as transparent and also seek your feedback and answer any questions anyone may have. The situation is as follows. The sheet I've shown you contains information about two properties, in particular the properties at 15 Southeast 10th Street, which is a property that is privately owned, and the property at 25 Southeast 10th Street, which is a property owned by the City of Miami. The property with an address at 25 Southeast 10th Street was deeded to the City of Miami back in 1974 with the specific intent that it be used and maintained as a park, which it has been all these years. As it happens, however, the zoning designation that appears presently in the zoning atlas shows, as you can see in the sheet, half green, which is the CS or parks designation, and half burgundy, which is a T648 zoning designation, which would allow for mixed-use development. Now, that has never been the intent, that has never actually happened, but what we must do to ensure that it continues to be maintained as a park in perpetuity is to rezone it as CS on the zoning atlas and therefore code it green so that it's consistent with its intended use. On the other side, at the property at 15 Southeast 10th Street, we have to do the opposite. There what we have to do is take the area that is shaded in green, which is mistakenly shaded as parks zoning or CS, and change it to the burgundy color so that that entire parcel can be redeveloped as a hotel, which is an application that is before us today. That's how it came to our attention that the zoning graphical error had taken place in the past. Again, in so doing, and I'll say in summary, in so doing we are simply captioning graphically in the zoning atlas what the intent was originally by ordinance of the City Commission, and I invite you to ask any questions or certainly receive any feedback.
Good evening, Commissioners. My name is Lita Rodriguez-Tassif. My address is 200 South Biscayne Boulevard, Suite 3400, Miami, Florida. I'm a lawyer and I represent the Allan Morris Company. The Allan Morris family donated the parcel at 25 Southeast 10th Street to the City of Miami to be used as a park in perpetuity. That was the intent. However, there is a current litigation pending between the City of Miami and the Allan Morris Company as a result of the fact that for several years now, the intent of the grantor has not been respected, and as a result, because the deed had a deed restriction that required that if any portion of the property was used for any purpose other than a park, that it would automatically and without more revert back to the Allan Morris family. So we are in the process of litigating
for
this
1
issue.
second, please.
Of course.
The 25 part. What is that? This side? Is that this part? This parcel?
No, it's one on top, right?
It's this parcel, Commissioner. This one right here.
The northern. Well, that's the southern one, right?
It's the Allan Morris Park, which is currently right next to Paracones. That's the one that I think we're talking
It's
about.
on the south side of Paracones.
There's two.
Not across the street from Paracones.
There's also a park
Another.
that's across the street from Paracone. They were deeded together by the Allan Morris Company and are supposed to be the Allan Morris Park. So the two parcels that are currently one next to Paracones and one right across the street, those are supposed to be the park.
Okay.
Anyway, Commissioners, what has happened here is we're mired in litigation. The litigation will be resolved when it is resolved. However, because the Allan Moore's company has filed a lawsuit, there is a lis pendens of record, and there is current ongoing litigation, and this is really not a correction of a Scrivener's error. This is essentially a zoning change, and because it is the position of the Allan Moore's company that this property has reverted back to the Allan Moore's company, and if a court determines that that is the case, it would have reverted as of the time that the deed restriction was violated. Then the Allan Moore's company asks that, to the extent that that there's going to be any correction of what is believed to be a mistake, that it be done only on the parcel that is the 15 Southeast 10th, and that there would be a correction of the error as regards the Allan Moore's, that there would be no correction as regards the Allan Moore's parcel, and that all that is corrected is the private property owned next to it. We don't care what happens with that property. You correct the error however you feel you need to correct it, but as regards the park parcel, we're in the middle of litigation, and it would not be appropriate to do so because it is our position that the parcel has already reverted to the Allan Moore's company, meaning we own it right now, and we should have been noticed, and we should have been provided with an opportunity to oppose this, and because it is the Allan Moore's parcel, it has reverted. Therefore, there is no need to change the designation from T648. Thank you.
I have a question for you, ma'am.
Yes, of course.
The property that was deeded over from your client to the city of Miami is considered parkland.
It would have been considered a park, yes, and was previously zoned as, prior to Miami 21, it had the park PS designation, and subsequent has the CS designation, but part of it is zoned multi-use, which is the T648.
And is that the parcel that is beyond this red boundary?
Correct. So there's, this parcel is the park, half of it is zoned.
We're not looking at the same.
Oh, are we looking
map,
at the same
so
picture?
It's a little different for me.
Okay, let me see.
Can you pass it? Yeah, that's worse. Speak into this microphone if you can.
Thank you, Commissioner. The Allan Moore's Park encompasses this parcel and this parcel. That's the Allan Moore's Park.
You okay? You can use
The Allan Moore's Park encompasses this parcel and this parcel.
Okay.
The correction needs to occur with regard to this, which is the Paracone parcel, or currently owned by another company, but that is where the correction needs to be. This parcel is mired in litigation because this is the Allan Moore's
So you,
park.
my question to you is that, but right now it's a park, and the proposal that's being made by the department is to continue it being named as a park. And so we're just trying to understand what your objection is to it continuously being named as a park.
While there is litigation pending, and if I
Sure, you can step back.
while there is litigation pending, the Allan Moore's family is not asking that the park be undone. However, there is no need to change the existing designation at this stage. Litigation is pending. The designation with regard to the park is twofold. There's part of the designation based on the map. Part of the designation is CS, which is the park designation, but the other half of the designation is the T648, which is mixed-use development.
Which is outside the boundaries of the parcel that is owned by your client.
No, part of the park is zoned T648.
But that's the part that's in Paracone's property.
No.
No.
Mr. Chairman, if I could.
Please.
This is in my district. I'm very familiar with this. I know we've been in litigation. There were some efforts to settle. Allan Moore's would like it back to develop. The city's pretty much taken the position that we believe this is our park and we want to fight for our park. But what I'm not understanding what you're contending at this point, are you saying that this was not a Scrivener's error, that this was intended to be T648? Because that's in contradiction to what I've understood from our administration. Because I believe that you would agree that it was intended to be CS completely in the donation, and when it was memorialized, there's simply a mapping error. If you're right and you win, of course, everything will go back to you and it'll be what it will be. But in the meantime, and I don't believe this is something we are voting on, our administrator, I mean, our planning and zoning director has the wherewithal to make this change without us, just to correct our map to what was intended by your client as well originally.
No, and here's why. There is now a discussion or a dispute because of the fact that this property was deeded with a deed restriction.
Agreed.
Whether or not it was intended to be CS or whether this is a Scrivener's error or a mistake is an issue that hasn't been resolved. And simply changing the map at this stage is essentially a zoning change to a piece of property that, if it reverts back to us, needs to be T648 because that's the designation that Allan Morris would seek if it reverts back. So it's been like this for 44 years.
So you would want to skip the step of having gone back from a park to T648. So that's what it's really all. No.
Well, the chairman has a great point, and I would just say that we can leave it at that.
Let's not speak more.
Because, we've given her a lot of leeway to explain everything she wanted to explain. But at this time, this is not even one of the issues in litigation. This is just a discussion item. Mr. Garcia has expressed to the commission what needs to be done, and we're pretty much done with this item.
Understood. Thank you very much, Mr. Garcia. Would you like to add anything else? No? Is that all?
Simply, sir, to say that the reason we feel compelled to move forward and correct what I will once again restate is an error in graphics only, is because in so doing we will be completely consistent with every ordinance passed by this city commission. And in so doing we will move forward and make the correction.
Thank you very much, sir. You're a gentleman and a scholar. Point two.
And one last point in closing. If this is an error, it has existed for 44 years. We're in the middle of litigation. Wait till the litigation is over to correct your error. There's no need to correct it right now. It's existed for 44 years. If this error is in fact an error, it needs to be believed.
Thank you very much. DI point two.